Welcome, everyone. I'm so happy to be here and have a few moments to introduce myself and welcome you to this wonderful program. I'm excited by NJCHS's selection of water. We're all talking about it. Many people are writing about it, and we have a future as the season starts. And today has all been about, in the news, preparing for floods. I'm Tani Cantil-Sakauye, and I'm the retired Chief Justice of California. But most recently, in this capacity, I am the president and CEO of the Public Policy Institute of California. It's a nonprofit charitable trust. We've been around for 30 years, and we do a great deal of work in the water policy area, and we have a water policy center. I'd like to take a few moments before I turn this over to Robin to tell you a little bit about PPIC's work in the water policy area. Our Water Policy Center is just one of our many focuses, but our Water Policy Center is one of our premier programs. It's been around here at PPIC for over 10 years, and it operates in the sense of a big tent of smart, experienced people of diverse water backgrounds who come together, who are all in their own right, premier researchers, advocates, who are all part of our team. We have a team of researchers here at PPIC, but we're advised by Water Policy Council that includes faculty researchers, including on this program, Brian Gray as a senior fellow. And we focus on three things. We focus on ensuring clean and reliable water supplies. We also work on building resilient ecosystems and preparing for flood, wildfires, and drought. Some of our most significant work of late has revolved around SGMA, the Sustainable Groundwater Management Act in California for the Central Valley that may take out of production and fallow, in worst case situations, up to 900,000 of agricultural fields and turn those into areas where we can recharge groundwater, our main source of drinking water. The Sustainable Groundwater Management Act was enacted in 2014. It is to be completed by 2040. There's no compensation for when we take this land out of production and fallow it or use it for other means. In fact, that's why we are planning so far ahead, and PPIC is playing a big part in trying to provide the data and the resources for that. I also want to say we do a lot of work in river community restoration. We are free in terms of our literature. We have reports and fact explainers and videos. We have a conference coming up that will bring national people on water in November. And pretty soon we're going to do a Water 101. And so I'm here to listen, to learn, and to also be part of that important conversation about water. And I turn it over to you, Robin. Thank you.
Thank you so much, Chief Justice Cantil-Sakauye. We so appreciate you being here with us tonight, and also the support and the really important work of the Public Policy Institute. I'm Robin Lipsky, and I have the honor and the pleasure of being the Executive Director of the Ninth Circuit's Historical Society, the NJCHS. A part of our mission is to educate about the vibrant legal history of the West, and more generally about the important role courts play in our lives. Tonight's program is part of a series of programs we're doing about water law around the circuit, and each program has a different focus. You can see our earlier programs from Hawaii, Nevada, and Los Angeles off our website, njchs.org. While you're on our website, I encourage you to sign up for our newsletter to hear all about all the other exciting programs we have coming up. Tonight's program is outstanding, and so I will save my thank yous until the end so that you have the most time to hear from our distinguished speakers. I'm particularly excited to introduce our moderator, Dr. Terry Young. It has been such a pleasure planning this program with her, and how wonderful for us to have an actual scientist with us here tonight to help bring an additional essential perspective to the evening. In the interest of time, I will give her a much briefer introduction than she merits. Dr. Young has dedicated her professional life to protecting the environment. She has a PhD in environmental chemistry from UC Berkeley and is the former chair of the San Francisco Bay Regional Water Quality Control Board. For nearly 4 decades prior to her service on the board, she provided advice regarding water quality and science policy to the nonprofit and commercial sectors, and served for 12 years on the U.S. Environmental Protection Agency's Science Advisory Board. Dr. Young, thank you so much for all of your efforts to organize this program with me, and I turn the program over to you.
Thank you, Ms. Lipsky, for the introduction, and a special thank you to the Chief Justice for your opening remarks. It's now my pleasure to introduce you to our panel. And as you will note, each of our panelists has practiced for decades at the intersection of federal law and public policy. And we're delighted to have them share their insights with us today. First, I'll introduce Hamilton Candie, better known as Hal Candie. Raise your hand, Hal. Thank you. Mr. Candie worked for more than 20 years at the Natural Resources Defense Council, where he was senior attorney and director of the Western Water Program. He's currently a partner at Altshuler-Berzon in San Francisco, where he continues to work on behalf of the environment. Mr. Candie is most well known for the successful litigation which turned about 60 miles of dry, pretty dead riverbed back into a river by restoring both water and salmon to the San Joaquin River. It was for this work that he received a California Lawyer Attorney of the Year, or CLAY Award, from the Daily Journal in 1999. Mr. Candie is also widely known for both his legal and public policy work on a variety of environmental issues, including endangered species, water for wildlife refuges, agricultural pollution control, and reclamation law. Felicia Marquez is the only person I know who has served both as the chair of the State Water Resources Control Board and as regional administrator for the U.S. Environmental Protection Agency. As a result of this experience, Ms. Marquez has a unique view into the interplay of state and federal law as they relate to both water supply and water quality. In addition, because she was head of the State Water Resources Control Board during the historic 2012 to 2016 drought, Ms. Marquez sat on the hot seat, basically, with people asking her to divide up too little water among too many uses. In addition to her government experience, Ms. Marquez has held leadership positions at the Natural Resources Defense Council, Trust for Public Land, and Heal the Bay, which she helped to found. She is currently a visiting fellow at Stanford University's Water in the West program. Brian Gray. Wait, Brian. After a stint in private practice, Mr. Gray became Professor Gray and now Professor Emeritus at UC Law San Francisco, formerly Hastings, where he taught environmental law, federal and interstate water resources, American Indian law, and a variety of seminars on related issues, including law and literature in the American West. In addition to teaching, Professor Gray has argued in the California Supreme Court and in the Ninth Circuit Court of Appeals in cases involving wild and scenic rivers, water rights, and takings as they relate to environmental regulation. Professor Gray currently is a senior fellow at the Public Policy Institute of California, as you just heard, where he works with an interdisciplinary team of noted experts to analyze the strengths and weaknesses of both water policy and water law in California, and to propose creative ways to improve them. Our program today will begin with a brief presentation from each of our panelists, followed by a conversation among them, and I promise you that will be lively. We'll reserve the time at the end for your questions. With that, Mr. Candie, would you like to begin?
Yes, thank you, Terry, and thank you all for joining. So I'm going to talk about a very old case about a very large environmental challenge, and that's about the San Joaquin River. They're going to put some slides up, and this first slide gives you a glimpse of one of the challenges we face, which is that the San Joaquin River was dewatered essentially for 65 years for over 60 miles by the United States government. And that was dewatered in order to divert the water primarily to irrigation districts in the San Joaquin Valley. but the picture gives you an example of what the problem was for a major river and having no water in it. The next slide is about the map. You see the San Joaquin River over in the lower right part of the map. And the river actually starts high up in the Sierra, north of Fresno, up near Yosemite National Park. And then it flows west to the valley floor and then flows north towards Stockton. But as it's flowing north, other important tributaries join that river and restore some of the flows for the river. Together with the Sacramento River, the San Joaquin and the Sacramento flow into San Francisco Bay, forming the largest estuary on the west coast of North America, which is a hugely important environmental area for fish, birds, and other wildlife. Also today, the Sacramento-San Joaquin River Delta is a source of water supply for over 22 million Californians as water is pumped south through massive federal and state pumps and other diversion structures. And you'll be hearing more about that from other speakers. This third slide shows the major dam on the main San Joaquin River, Friant Dam, which on the map was identified as Millerton Lake. That's the reservoir behind Friant Dam. This dam is owned by the U.S. Bureau of Reclamation, which is part of the U.S. Department of the Interior. The dam diverts over 95% of the natural flow of the river, where it is delivered up and down the east side of the San Joaquin Valley, again, primarily to irrigators. The government only released small amounts of water for some downstream landowners who lived very near the dam. But since the 1950s, there were no releases for the river itself, including for fish and wildlife or for water quality. This had huge resulting impacts, including wiping out a major salmon run, devastating water quality, dewatering downstream wetlands, and impacting fish and wildlife habitat for many miles. Starting in the late 1980s and continuing for the next 3 decades, environmental and fishing groups tried to call attention to the plight of the San Joaquin River. Here's a slide from a KQED article noting that the river was designated the most endangered river in the country in 2014. The goal of the campaign was simply to change the operations of Friant Dam, which were causing the river to be dried up. After all, since the dam was built back in the 1940s and then permitted to run full operations in the 1950s, so much had changed in terms of environmental laws and in terms of other water needs in the state and in terms of the potential for water conservation. So in 1988, a coalition of organizations led by the Natural Resources Defense Council, or NRDC, filed litigation challenging the federal government's operation of the dam and its operation of the Friant Division of the Central Valley Project. Specifically, we focused on 2 major objectives. The first was thinking about why Reclamation didn't voluntarily agree to release some water. We went to the Bureau of Reclamation, went to the top officials in the Reagan administration and said, why don't you change your operations, conserve some water, and release some for the river? And we were told, no, that would be impossible. The diversions are memorialized in binding long-term federal water contracts. And in their view, those are supreme over all environmental laws, both federal and state. So our first major policy objective was to do something about those long-term federal water contracts. And specifically, in challenging the contracts, we looked to procedural environmental requirements like the Endangered Species Act and NEPA, the National Environmental Policy Act. And also, we looked at the very key fact that those long-term contracts, those 40-year contracts, were starting to expire very soon, in fact, in the late 1980s. Even the US EPA and other federal agencies agreed with us that environmental laws like NEPA actually do apply to the renewal of federal water contracts, and that the initial sweetheart deals handed out in the 1950s and 60s were not locked in for all time. Our second major policy objective was to make sure, either indirectly through contract reforms or directly through other strategies, that water will be returned to the natural system, to the river below Friant Dam, to help mitigate and undo some of the damage that had been done. In seeking legal handles to require water releases for the environment, we looked to the Mono Lake case as an important model. Recall that the city of Los Angeles had been required to give up some of the water it had been extracting and diverting from streams on the east side of the Sierra in order to protect public trust values at the beautiful Mono Lake downstream. The most powerful and direct weapon, in our view, in the Mono Lake battle had been Section 5937 of the state's Fish and Game Code, which Cal Trout had used in the Mono Lake context. This 100-year-old statute applies to every dam owner in the state of California, and it requires every dam to release enough water to keep the fish below the dam in good condition. But in the 1950s, the state had explicitly waived that law's application to Friant Dam because it was a federal dam. In the view of the State Water Board, a federal dam was not subject to state laws protecting fish or fishing interests. Thus, a big focus of our case was going to be on salmon, the main fish existing below the dam who are not in good condition. And you can see from this slide that before the dam was built, we had hundreds of thousands of salmon swimming upstream on the San Joaquin River, sometimes as many as 500,000 spawners. After the dam was completed and started operating, there were still some salmon coming back. But once the full operation of the dam began, the spring run salmon, the salmon runs were basically extirpated from the river. The historical numbers were dramatic. It was a very important salmon fishery. It basically was wiped out as a result of the operation of Friant Dam. And that was a big focus of the litigation. I will not detail the ensuing 12 to 14 years of legal battles that followed, most of which our side won, but which took enormous amounts of time and political capital and going to the district court, to the Court of Appeals, and back to the district court, as the irrigation districts and the federal government used all of their substantial resources to fight us on every procedural point imaginable. All, it seemed, just to avoid simply looking for ways to conserve some water, share some with downstream communities, release some for the natural environment. In fact, the Democratic Clinton-Gore administration actively opposed our lawsuit, yet we kept winning in part because Justice Rehnquist of the US Supreme Court had ruled in a California case that the federal water projects that go into Western states actually are subject to state water laws unless there is a clear conflict with an express congressional directive. Because some of these core legal issues were relatively new and had not been thoroughly litigated before, there was an extraordinary amount of litigation, both at the district court in Sacramento and at the Ninth Circuit. Finally, in 2004, federal judge Lawrence Carlton in Sacramento held that the Bureau of Reclamation's operation of Friant Dam was violating Section 5937 of the state's Fish and Game Code, and that provision of state law was applicable to the federal dam at Friant Dam because of federal reclamation law. And he told the parties to prepare for a long remedy trial about how much water to release. Then a year later, in 2005, at the encouragement of Senator Dianne Feinstein and others, and on the eve of that 2-month trial about how much water should be released, the parties agreed to engage in serious settlement talks. Represented at the negotiating table were 14 plaintiff groups, both fishing and environmental organizations, 5 federal agencies, and over 18 irrigation districts. After 1 full year of talks, a sweeping settlement agreement was approved by 55 different parties and then by the federal court. And then in 2009, legislation authorizing the settlement was approved by the Congress and signed by the president. The settlement is lengthy and complex and includes both environmental restoration measures as well as water supply measures for the Friant water users. Today, the parties continue to implement the settlement, and it provides benefits for all sides. On the restoration side, the key to the settlement was reintroducing and restoring salmon to the main stem of the river. This next slide, which is up there, you can see talks about an experimental population of reintroducing spring run Chinook salmon to the main stem of the river, and actually having some salmon return to spawn in first time in nearly 65 years. Although various complex restoration projects and the return of adequate in-stream flows will still be crucial to successful salmon restoration, these initial early salmon reintroduction efforts were very encouraging. Although we have had important successes, we have also had to fight off opposition and resistance, both in California and in Washington, D.C. And we've had to also contend with budget shortfalls and unprecedented droughts. But we continue to make progress. And although it's been much slower than many of us in the plaintiff coalition had hoped. The final slide is about what we call the reopener clause. Some settlements are not necessarily frozen forever. In the case of the San Joaquin River settlement, that fact is explicit. As is shown in this slide, in less than 3 years, the plaintiff coalition can go back to court and reopen the key issue in the settlement about how much water must be released from the dam for the downstream environment, versus continuing to be diverted to the agricultural communities along the 2 big federal canals. An elaborate process for such a reopener is spelled out in the settlement. The long history of the San Joaquin River litigation and the long settlement process and the settlement implementation process has included an amazing array of federal and state legal challenges and opportunities, and also a host of political challenges and opportunities. Just to cite one example, a congressman from the Friant service area that some of you may have heard of, a man named Congressman Devin Nunes, always hated the settlement, even though the irrigation districts, in fact, every irrigation district in his congressional district who received water from Friant Dam had urged him to support the settlement and not to oppose it. But on multiple occasions, he introduced legislation in the House to repeal the whole thing. He never fully succeeded, although he did get his legislation passed twice by the House of Representatives when the Republicans were in control of the House. This gives you just an example of some of the challenges we faced. However, as you all know, the Congressman Nunes is no longer in Congress, and the settlement has continued to be funded by Congress every year and is continuing to be implemented. This concludes my very quick overview and summary of the San Joaquin River case and the settlement. I could go on for many, many hours about it, but I will just stop right there and thank you very much for listening.
Thank you very much, Hal. And I think many of us will be on pins and needles until 2026 so that we can find out what happens. Hope it meets your every wish. Ms. Marcus, may we hear from you next, please?
No, happy to. And 2026 is going to be a pretty big year, as you'll see in a minute. And let's see, I'll wait for the slides to come up. Thanks, Audrey. Terrific. Well, I'm thrilled to be here, thrilled to be on a panel with two of my favorite water lawyers, and always honored to be able to be in the presence of the amazing Terry Young. And I want to thank Terry Robin and the team for including me in this August panel. I'm going to build off Hal's comments where he talked about a huge specific case where the interplay between the state and federal frameworks were so important. I mean, in fact, if you think about California water law and you think about Section 5937 that Hal raised, a key decision point that led to the settlement in that case, I think the Friant case may be the strongest application of that piece of state law in terms of leveraging action. And it came in a federal case as opposed to a state case, which is just interesting. So you have these bucket of tools that sometimes work together, sometimes don't, and sometimes you can pull them together. So what I'm going to do instead is I'm going to give you just a number of examples where that interplay also exists before being able to hand you back to Brian for a particular set of suggestions for where we can go into the future, which will be really interesting. But basically the bottom line is going to be one size doesn't fit all. So here's what I'm going to do. The introduction, I'm going to just do 3 quick observations about California water, because unless you have a feel for California water, the federal state interplay might not seem as significant. And some of it is just my observations on how to think about California water. And then I'm going to go through 5 quick examples, spending a lot more time on the Bay Delta than on the other ones. And then if there's time left over, I may talk nature-based solutions and technology, but I may just save that for conversation because I think we're going to have a lot to talk about. One thing to begin with is that generally water law is left to the states, not water quality so much, but water law is left to the states. It's among one of the most sacred, so to speak, of states' rights. In fact, in the Clean Water Act, there's a provision known as the Wallop Amendment, which is Section 101G, that has been described as EPA, keep your mitts off our water. It sort of prohibits EPA from messing in water allocation issues, although there have been some very clear decisions that EPA decisions on water quality, think temperature or salinity control, can have an impact on allocation, but the federal government can't make that allocation. So that's a really bright line. It's one that gets fuzzy in application, but it's really important to know that on a lot of the federal and state issues, there will be people who will tell you that there's only one way to go and that somebody's completely out of line. Just as Hal was talking about about how state law applies to federal projects, that took a while to be settled and is still in contention pretty often. Next slide. So here's an observation. This is just, one of my favorites. Yogi Berra said a lot of things and people remember a lot of them like it's deja vu all over again. But my favorite is, in theory, there's no difference between theory and practice. In practice, there is. And that applies to California water law in so many ways. So again, I know that a lot of times when I talk about water, I'm trying to arm people against the jerk at the dinner party who says there's just one answer. And if those bleeping idiots, whether it's the government or it's a farmer or it's an environmentalist, or you pick whoever you're not, you will hear that. And in fact, California water is pretty complicated, and it's complicated both in theory and practice. Next slide. So I'm not going to go through this, but just to make the point. My husband hates this slide because there are too many words on it, but I did it as a wallet card. In fact, I actually have a whole set of them that people asked for that I need to cut apart and laminate. And it was largely because I had been in the water world and helped negotiate something called the Bay Delta Accord, which I'll talk about in a moment, which was very much involved in the interplay between the federal and state government. And it was something where we spent a lot of time with a lot of stakeholders from government, private sector, NGO world around the scene. And it was very hard to get people to come to agreement because they had very clear ideas of one narrow piece of California water. So I left and went into land conservation, as Terry referenced, where people knew how to make a deal, and they knew how to make a deal with people that didn't start out in the same mindset or same place as them. But then I got drawn back in when I went to NRDC. I immediately got pulled back into the water world, I guess, because people needed a social worker who could get along with everyone. And I was immediately struck by the fact that I had the same people talking past each other with the same talking points, not listening to each other or seeing the bigger picture. So I thought of the parable of the blind man and the elephant, where they're each touching a part of this creature, trying to explain it, and it couldn't possibly be one creature. And you need to understand that about California water. So this slide was done as a wallet card to help folks understand that there's not one thing. And I won't go through all of it. Happy to send anybody a wallet card who wants one. But the key thing to know about California water is it has the most variable hydrology in the country. It wide swings year to year, doesn't fall where it's most used, doesn't fall in the time of year where it's most used. This is different from the East. So it sets the West apart, and California even more so than the rest of the West. The other thing is that every place and every locale has a different mix of sources. So you will hear people talk about California water as if it's one bathtub of water and everybody should have the same view of it, when in fact it totally depends on whether you get surface water, you get imported surface water that's from hundreds of miles away, you have groundwater, you have a mix of all of them, you have only one of them. Every locale is different. Every locale, people have a different mix of water rights. Some are senior and will get 100%, except in the most dire of drought. Some are junior, like the state and federal water projects, who frequently will not get their full allocation of water. So when you hear that only 5 or 0% are handed out, it's not as if they should have expected 100. Of course, everybody always wants 100, but nobody expects it if they, or should expect it if they're junior. And so as a result, of course, there are a mix of solutions. We can't conserve, recycle our way out of it. We can't build dams and build our way out of it. We have to do all of the above: storage, big and small, above ground and below. We can't possibly deal with the challenge of climate change through surface storage alone. We're going to have to figure out how to recharge our groundwater basins. And that's something that is not the topic of today, but being worked on very heavily all across the valley for the reasons that the Chief Justice mentioned, trying to figure out how to adapt to live within our means, but also how to manage our groundwater basins so that we can get water in them when we have them to make up for the snowpack that we're going to lose with just a few degrees temperature rise due to climate change. Because to the extent that we've had water wars up till now, all of the conflicts we've had till now will seem like a picnic compared to what's to come as we lose our snowpack, which is our single largest source of storage, as it holds the water back in its frozen form to melt out slowly, to restore our reservoirs, which aren't a one and done. They get refilled, our streams, and also our groundwater basins. So a big leap and a lot going on that we need to deal with. Next slide. Again, headlines are always about the fighting, the apocryphal Whiskey is for Drinking, Waters for Fighting attributed to Mark Twain, and also just these epic battles between the stakeholder groups all of whom think of themselves as the kitty and not the Godzilla. So that said, though, we'll talk a lot about those fights and challenges. There's actually a lot going on the ground with people in communities working together, farmers, local governments, NGOs, to try and transition some of the overdrafted groundwater basins to places where farmers are farming water molecules, creating wildlife habitat, and providing multiple benefits for their communities. But we won't be talking about that today. Next slide. But the main thing I wanted to talk about a bit was the Delta to follow on. This is one of the epicenters of federal and state activity, although it is varied over time, just as our hydrology varies, our politics vary, and our attention varies. If we look at the Delta, it is pretty much the central challenge at a physical and political level in California. Almost every region of the country has something like this, and this is ours, whereas Hal pointed out the San Joaquin runs north, the Sacramento runs south, Sacramento being about twice to 3 times as big as the San Joaquin, with many more tributaries, and filters out through this web of Delta islands that were reclaimed or created for farming in the middle of the 1800s. It's the hub of our hydrology. Over 40%, I think, of California's water flows through there. It's the hub of a lot of physical infrastructure, not just water infrastructure, and political fights that have gone on across the decades, sort of the ages between environmentalists and commercial fisher people, agricultural interests, urban interests, recreational interests, and the like. It's a plumbing issue, to be sure, because of the way the state and federal projects have their pumps at a very delicate part of the South Delta. But most of the discussions that you hear about the Bay Delta in the news tend to focus on issues of whether you should have a tunnel underneath or not, which I'm not going to address today. It's pretty much very much a state issue until it comes to the NEPA process and the Corps of Engineers, what's known as 404 process. But the main process that the state uses to deal with it is called the water quality control plans, which are done under the State Porter-Cologne Act, which served as the model for the Federal Clean Water Act. The Clean Water Act also has requirements for updating water plans, basin plans, which are supposed to look at all of the interests, not one, but all of the beneficial interests in it. It can be agriculture, recreation, fisheries, fish and wildlife, recreation, you name it, and try to maximize all of those interests. And the water board that I served as chair of has been tasked with updating that plan, because it does integrate water rights and water quality, which the state water board is uniquely positioned to do. Now, what happened in the earlier part of the 20th century was the water board had been poised to update these plans to give more water flow to fish and help with algae blooms and stuff in the Delta proper, which is important for fish, but also for people, and fish are important to people. And it was pulled back for a variety of political reasons by first Governor Duke Majan, and then on another try, Governor Wilson. And what ended up happening was the environmental community sued under the Clean Water Act and a number of other statutes. It was settled by the federal government. Then support from both the Bush administration, regional administrator who preceded me, and it was settled before I arrived as the regional administrator, for the federal government to step in and EPA to step in and set standards in the absence of the state's ability to actually do the job it was supposed to do under state and federal law. It was then settled, and it was settled with the federal government being on a schedule to propose a proposed set of standards in December of 1993. I got there in October, I think. And then to finalize it a year from then, if the state hadn't come together with all the stakeholders to come up with a plan that would be approvable. To make a long story short, after a year of meetings with all kinds of stakeholders, all sorts of governmental entities, it was sort of death by meeting, and a lot of shuttle diplomacy and a lot of alcohol and coffee in coffee shops and bars. We came to an agreement known as the Bay Delta Accords, where there was a set of standards that would have been approvable. Big a big party, pieces broken out, and we made some progress. But as time went on, it was clear that that wasn't enough. And so more recently, the State Water Board, during the time I was the chair of the board, was engaged in trying to update those standards, enormous fights. But that was a period of time where the federal government has been less involved. And the state, fortunately, was able to do the first half of those for the lower San Joaquin River in 2018. And unfortunately, the further progress for the rest of it has been delayed, but recently restarted by the state board. The big question is whether the federal government would actually step in this time or not. And that's a longer political question, but both sets of rules are at play. Next slide, then we'll go quickly through them. The reality of it is that as we delay, death is delayed to the fish, and we've had a steady decline, even without dewatering 60 miles of the rest of the delta. Sometimes 80 to 90% of critical tributaries are diverted during critical times of year, and we're facing Armageddon for fish. Next slide. And an interesting new chapter in it has been prompted by petitions to the US EPA under civil rights, Title VI of the Civil Rights Act, in that the delay in doing this, as well as some of the processes, are violating the civil rights of tribes and environmental justice communities. So that's something to watch. The EPA has just accepted it for investigation. Next slide. And then just something else, a few other things to put on the plate to think about. A Clean Water Act Section 401 is one of my favorite sections of the Clean Water Act. It used to be 301H, which is a sewage related act, but it's one which allows state officials to set water quality parameters on any federal project, and dam relicensings are a big part of it. Gas pipelines are a big part of it. And Sandra Day O'Connor wrote a fabulous decision in PUD #1 of Jefferson County versus Washington Department of Ecology about the interplay of water quality and water flow, and how the two can't really be separated. Next slide. Unfortunately, it kind of came to a head in the Klamath Dam decisions, where the state board, in trying to be helpful to this incredible array of partners, federal government, state government agencies, Oregon, California, a number of tribes, agricultural interests, and Pacific Corps, which is one of the owners of dams along the Klamath River, were close to reaching an agreement on taking the dams out to finally restore that river. It's now in process. You should be watching it. It's very exciting. The dams are coming down, but at the time they were just close to an agreement and then couldn't quite get there, or there was a holdup at the federal level in terms of getting the legislation that was really essential to get. And so we kept putting this, it was in the context of a petition for relicensing, into what's known as abeyance. And there is language that says states only have a year to do this. A year is never enough if you have to do something like a CEQA process. A year is never enough if the proponent is the one who has their hand on the clock in terms of giving you the information you need. And so it's fairly common practice to either hold it in abeyance for a year or have someone withdraw and resubmit. But we ended up losing a case on that for a while, but fortunately we're able to do the certification in time to let it go forward. But this interplay between 401, between the federal and state governments, is very much a live one. Next slide. I don't have time to talk about the Colorado River, just to say this is a place where the federal government has a tremendous amount of authority, because they're essentially the water master on the river, 7 states. So it's an interstate river. And this is probably the most high profile issue in the last couple of years. We got bailed out by the snowpack-a-palooza that we got last year on the Colorado as well in the Sierras. But this agreement too, that has pulled together all of these states and now 30 tribes and 2 countries, is up for grabs in 2026. So watch that space too. And then finally, last slide, sorry, I'm gone late. The Clean Water Act's finest hour. I could not mention sewage, because the Clean Water Act's driver on sewage has really affected a tremendous change and affected states all across the nation. Probably one of the greatest success stories, even though there's still a long way to go. Stormwater being the next frontier. It's based very much on the Porter Cologne's leadership in California. And I just wanted to put the Ninja Turtle picture up because they live in the sewers and eat pizza. Thank you. Last slides. And I'm in the Ninja Turtle suit, so that's my favorite self-portrait. Hal, I used all your extra minutes.
Well, thank you, Felicia, for a riveting short course in the tangled history of federal versus state water policy, water law, and who drove which when. I really appreciate you laying it out so clearly. And now we will turn to Professor Gray to tell us what we should be doing next.
All right, thank you, Terry. I must say I was very relaxed during Hal's wonderful presentation. And then when Felicia started talking and put up the Yogi Berra slide, I got very worried that the Yogi Berra quote is going to come back and bite me before the evening is over, but we'll see how it goes. So what I'm going to talk about this evening derives from work that my colleagues at PPNIC began about 12 years ago, in which we suggested strategies to move away from the traditional single species, single stressor regulation toward more integrated and holistic ecosystem-based management. And I just want to note at the outset that beginning under Felicia's tenure as chair of the State Water Board, the board began doing the same thing and taking a much more holistic, again, integrated approach to water quality as well as water rights. What I want to talk about today is the creation of ecosystem water budgets for California's most important river systems. And in coming up with this idea, we had two essential goals. The first was to define environmental water as an asset rather than as merely a constraint on the exercise of water rights, and to enable more effective, flexible, and efficient management of water that's assigned to ecological uses. So ecosystem water rights would represent the total quantity of water assigned to, that is budgeted for, aquatic ecological functions. And these water budgets would be principally comprised of water that is currently set aside to comply with laws such as the state and federal water quality laws, endangered species obligations, Section 5937, which Hal and Felicia both mentioned, the public trust doctrine, and other environmental requirements, as these standards are revised from time to time. And the ecosystem water budgets would be augmented over time through short and long-term acquisitions of water through purchases, exchanges, and donations, as is currently authorized under California law. So we try to come up with a management structure for these very important endowments or assets. And we propose that the environmental water budgets be managed by an ecosystem trustee for each watershed on which an environmental water budget is created. And the trustees would be guided by 5 to 8 year management plans that would define the biological and ecological objectives, and then articulate strategies to achieve those objectives using principles of ecosystem-based water management. And this would include functional flows and integrated habitat restoration and management. And these long-term plans would then be supplemented by annual watering plans, which would guide the implementation for each upcoming water year, and taking into account things such as existing and predicted hydrologic conditions, stored water availability, and short-term ecological requirements. And the trustees would then employ real-time adaptive management in response to changing hydrologic and ecologic conditions. The trustees would have authority to flexibly deploy this ecosystem water, this budgeted ecosystem water, including the authority to store water, purchase and sell the water, and engage in lieu exchanges and groundwater and surface water banking. So one of our goals was to really add flexibility to the administration of water, again, currently set aside for environmental uses, to allow it to be managed more in the form of a water right, as I'll describe in just a minute. So who would these trustees be? Well, there are a variety of possible management structures for the ecosystem trustee. What we recommend is that an individual be assigned that task for each, again, for each watershed. And you might have a committee of trustees that would deal with situations where, again, as the water flows downstream, you go from one watershed to larger watersheds, and you would need some coordination. And so you might have a committee of trustees where each of the individual trustees would get together and coordinate their decisions. The trustees must have a significant measure of independence, although they would work with reservoir operators, other water managers, water users, and regulators in developing and implementing the management plans and the annual watering plans that I just described. And as noted, the trustees should have their own or should have access to a science advisory group, including hydrologists, fisheries biologists, ecologists, climatologists, engineers, and forecasting data specialists. The scientific component is really essential to making this work. And we think, perhaps we can talk about it a little bit more in the discussion. I'd really like to get Hal and Felicia's views on this. We think that the San Joaquin River Restoration Administrator that was set up under the San Joaquin Settlement is a very good example of this type of structure. So as I alluded to a few minutes ago, the trustees would manage the ecosystem water budgets in the form of ecosystem water rights. We would grant them the same status that other water right holders have to manage this asset as other water right holders make decisions to manage their water endowments as well. And the water that is assigned to fulfill regulatory standards within the ecosystem water budget would hold first priority, along with water needed to fulfill the human right to water within each ecosystem. And we don't think of this water currently as having first priority, but the water, again, that is needed to be stored and released for things such as to meet water quality standards, endangered species requirements, other environmental standards, that functions really as a top priority within the system, even though we don't call it a water right. So we would declare this the top priority water right within each system. And then consistent with Water Code Section 1707, water within the ecosystem water budgets that would augment these standards would carry the same priorities held by the transferors or the donors of water that would contribute to the ecosystem water budgets. This first priority is important because it would enable the trustees to require junior water right holders to cease diversions or otherwise ensure that water is available to fulfill the objectives of the long-term and annual watering plans. And again, this is akin to the rights and prerogatives that senior water right holders have to make calls on the system to honor their senior water rights, to fulfill their senior water rights during times of shortage. And it would also enable the trustees to call for the bypass or release of stored water to fulfill these same senior water rights. And in addition, water currently stored in reservoirs to meet downstream environmental requirements would also be managed by the ecosystem trustees, and the trustees could store additional water in reservoirs through contracts with the reservoir operators. And we think this is an essential component because dams control the flow of most of California's, or really all of California's major rivers, and releases of stored water from reservoirs supplies much of the water that we currently use to serve ecological functions, and this is especially true during times of drought. So I want to mention funding just briefly. As I said at the outset, the ecosystem water budgets, as we have conceived them, would be essentially seed funded through the incorporation of the water that is now set aside for compliance with current and revised environmental regulatory standards. In addition, we think it would be very useful, if not essential, to have a public goods charge on water diversions that would help to pay the costs of administering the ecosystem water budgets, including the scientific advisory groups that are essential to this whole endeavor. The storage and diversion of water have significant and largely unaccounted for external costs, and we think it's therefore appropriate to charge a fee that helps to pay the costs of mitigating some of these environmental externalities. Revenues from water transfers and exchanges would also contribute to the funding of the ecosystem water budgets, including the acquisition of additional ecosystem water to help meet long-term management goals and to shore up supplies during times of drought. The ecosystem trustees might acquire dry year options, as other water users do, to give them the right to additional water during drought conditions. So we think there are a number of advantages to this approach over the existing or traditional regulatory structure. The first is that integrated ecosystem-based management of environmental water, especially as guided by functional flow principles, would be more effective and efficient than the traditional constraint-based regulatory systems. Second, defined ecosystem budgets would create greater certainty both for in-stream beneficial uses and for extractive uses of the available water. That's what a budget does. Third, independent trustees, in our opinion, would better manage the assigned environmental water than do project operators whose principal purpose is water supply to their members or contractors, although subject to regulatory constraints. There's an inherent conflict of interest when project operators and water managers are asked to be both water suppliers and environmental stewards. Fourth advantage is that defining ecosystem water as a priority water right would make it less likely that water assigned to water quality, flows, and habitat will be encroached upon under conditions of systemic shortage, as has occurred during each of the last several droughts, usually through things such as temporary change orders issued by the State Water Board or other regulatory and operational decisions that place an inordinate risk of shortage on environmental uses. And finally, we think that on-the-ground administration of ecosystem water by independent trustees within each watershed would enable more effective supervision of regulatory and water rights compliance than is possible under the current, more centralized system. It also could help to facilitate collaboration with other water users and stakeholders, and therefore perhaps could help to reduce conflict within the watersheds. So the State Water Board is putting some of these ideas into action now, including creation of environmental flow standards, as Felicia mentioned, for the Sacramento and San Joaquin Rivers and their tributaries, as well as the adoption of biological objectives for the lower San Joaquin Basin. And this really confirms our analysis that much of what I've just outlined could be accomplished consistent with existing state and federal law. We do think, however, that clarifying or enabling legislation could be helpful in authorizing the creation of ecosystem water budgets, recognizing ecosystem water rights, and defining the appointment, responsibilities, and accountability of the ecosystem trustees. The administration of ecosystem water budgets and water rights would also have to fulfill water quality standards and endangered species requirements, and reservoir operators that store and release water at the behest of an ecosystem trustee would continue to comply with the rule curves and other regulations that protect public health and public safety. And again, we think that the San Joaquin Restoration Administrator is a very good working model for that type of relationship. Other aspects of the proposal, especially a public goods charge, probably would require state legislative authorization. So I want to conclude by just noting that the draft voluntary agreements governance plan, which the State Water Board released last month, incorporates many of these principles, including new fees on water diversions, and it also creates an ecosystem water budget of sorts. The draft describes how water agencies that are participating in the VA negotiations have committed to dedicate additional water for environmental purposes, and it explains that this water would be, quote, adaptively managed to benefit native fish populations and habitat and protected for delta outflow. The draft also notes that in some water years, these commitments could add as much as 825,000 acre feet to the flows resulting from the 2019 biological opinions and the State Water Board's decision 1641. And these are the principal laws that govern endangered species compliance and the water quality regulations. It then states, and I'll quote, that the proposed flow measures for the VA program can be flexibly managed based on timing and season to increase in-stream flows and delta outflows and test biological hypotheses consistent with regulatory requirements. And I was very surprised to see that, and actually very encouraged to see the encouragement for that type of flexibility in the voluntary agreement and water quality administration process. So I guess I would conclude by saying that this is all a really good start. But what I think we need now is truly integrated management of all water assigned to ecological uses, managed by independent trustees based on objective science and reliable biological objectives, and administered under a well-defined governance structure. So Terry, I'll turn it back over to you. Thanks.
Well, you turned it over to me just in time for my brain to explode with all of the things that you just put on the table.
That was a lot, and I apologize for that.
I will ask each of our panelists to unmute themselves, and we can start to have our conversation. Anyone want to dive in?
Well, I would be curious what my co-panelists think. Did I violate the Yogi Berra principle? Or is there a great risk of violating the Yogi Berra?
Well, Brian is not only an old friend, but a former co-counsel of mine. And I am really always struck by how creative and intelligent he is when he deals with these questions. And I'm so grateful that he is trying to think in new ways. I have become somewhat of a pessimistic person over the years, because every time it seemed like a good idea and a good proposal was out there, we found somebody in the very complex California water system gaming the system a little bit, trying to find a way to game how you calculate things, or game whether water has two uses and do you double count or not double count. And so I guess my first question to Brian would be, how do we pull this off? Because it's not easy, I have found, to get consensus on what the terms mean, consensus on what the quantifications should be and are, and where the power really is in terms of administering it. So great idea. I love the idea of using the public goods charge to generate revenue, but just curious if you have any thoughts about some of the pitfalls that may be out there.
Yeah, I mean, I think there are many. It would not be an easy process. I mean, again, and Felicia, please add on to this. But I mean, I think the board has begun to experiment with some of these ideas. I was, again, as I said, I was particularly struck by the fact that the board seems to want to use the voluntary agreement process to build in some flexibility for the administration of at least some of the water that's dedicated to environmental uses. These would very likely have to be negotiated agreements. They could be what I described could be incorporated to voluntary agreements. I think the board would have pretty broad authority if it wanted to, if the voluntary agreement process does not succeed, to impose the flow standards that it has already stated it's going to do, the minimum flow standards, but then appoint a trustee for watersheds to allow the trustee to manage those flow standards, again, pursuant to long and short range plans that have explicit biological and ecological objectives attached to them, and then build the same type of flexibility into the management that the board has already suggested is appropriate. So I think there are ways to do this, even if everybody doesn't come together for some unprecedented kumbaya moment and agree to everything. I think, again, probably board appointment of the trustees and board supervision of the trustees would be essential. I mean, these trustees, as I said, really need to have independence. They need to function with the same type of rights and prerogatives and independence that water right holders have. So that would be an essential component as well. But again, we were struck by the fact that that the administrator system that you set up in the settlement, seems to be working from all of the interviews that we conducted. And again, I would hope that would serve as something of a model as well.
Well, I think it's an interesting question. I mean, I'm sort of mixed. I think there is this distinction between theory and practice. And there's a lot in theory that I like about it, obviously, because we proposed an opening for the voluntary agreements for the reasons we've talked about before, which is, I do think that if you have a group of people around a given water body talking about how to meet fish needs with some water to work with, a bucket of water to work with, they're going to start being more creative and figuring out what to do with it. And you will liberate them from the political overlay of the not one drop club, the lawyers, lobbyists, and politicians who gain by the fight. So part of the value was doing that and coming up with a bucket of water. The issue is that the bucket of water, the amount of water has got to be set by regulation. It's not a voluntary agreement or a regulation. We are overdue under federal law for sure and state law to update these standards. And it's everybody's dropped the ball on this thing, and you're never going to get a good agreement unless you actually have regulations driving them. But the regulation, the agreements, or this structure you're talking about could be a better way to implement. So to me, the issue, it's not one or the other, it's moving ahead to set the regulations where the science really suggests, as opposed to what the body politic or the particular political people you're listening to will bear, which is where we are right now, with some framework in the voluntary agreements that has promise, but has very little more promise than it had in 2018, when people said they were on the verge of an agreement. And it's not an agreement, it's an MOU to do an agreement. So I just think it's critical to get those regulations put together.
Yeah, and if I could just add, I agree with that completely, Felicia, and that's just
there's just not enough water.
Yeah, and to emphasize, because we need a significant amount of water to accomplish the purposes, that's why we propose and feel very, very strongly that the ecosystem water budgets would have to be seed funded. They would incorporate that water that is now set aside under state and federal law and regulations, again, as revised, as updated based on current science and changing conditions warrant. So again, I agree with you. And going back to Hal, what you said, I mean, I'm not wildly optimistic about any of this either. Although I have been encouraged that this idea or elements of it have gained some traction in various places, including the VA negotiations.
You know, an interesting thing is, I mean, there are a lot of different ways to come at that. I love your public goods charge. I think that would be, because water is starved of the money we need for planning, and it's the opposite of energy, where we've been able to work a miracle in efficiency and climate change adaptation, all kinds of things, because of the fee. But it's a political third rail and very hard to get. We couldn't even get a small one to help the most underserved communities. And fortunately, Governor Newsom dropped what we were trying to do with a very small fee and just took it from climate change, the climate fund, which is fine. But we really do need one. We need one to develop new technologies. We need one for all kinds of reasons. I was a fan of the idea that was floated but didn't pass, of putting $2 billion aside to buy some real wet water, senior water rights that you could dedicate to the environment, as opposed to us always being in the constant fight. Because the issue with the constant fight is that the fish lose, and the people who live in those communities lose, and the people who depend on fish for sustenance and cultural practices lose, because delay is a win for the water users, and delay and litigation and continuing to negotiate the same old thing is a win for the water users. And I don't dislike water users. That water users are an important part of those multiple beneficial uses, but there are some that get left behind all the time: tribes, subsistence fishers, fish and wildlife generally. And so there's a need for some combination of money and a better way to do things in an environment that's fraught. The other thing, though, that I think is a challenge here is the fact that we don't have, and this is a whole nother presentation, that we don't actually have a built out water rights system, where you can't be assured that that water is going to get where you want it to go. 1707 or not, we're the least quantified of any of the Western states. We're making a little bit of progress. This administration's put 60 million into digitizing the paper records we have, and into giving some small beginning of an enforcement staff to get people to comply with the measurement rules that we were finally able to set in 2016. But if you don't have a truly quantified and workable water rights system, no one can be assured that water is going to get where it needs to go, whether it's a fight between water users or a fight between the fish and wildlife and water quality water. And so our system is just so far behind where it needs to be a modern system, that we don't have the foundation upon which this could really work. It's what we should aspire to. We also can't, our water markets can't work in any broad scale, because we can't, there's no assured quantification of everybody's water rights either.
Yeah.
So we just have a loosey-goosey system. And my final point is just, in theory, I think it's good. And I do think there are elements of this that are helpful, particularly if you can get the trustees to be those that are somewhat isolated from the day-to-day politics, which is what the state board is supposed to be, as an independent board or department, but it very much depends on which administration is in power at the time. And so there's no assured bet, particularly also when you have a federal government and a state government of the same party. So there's going to be more reluctance to come down hard on the state when they're of the same party. Whereas when we did the Bay Delta Accord, we were dealing with a different party. And so we were able to be tougher as feds.
Yeah. If I could just a quick note on water rights enforcement and monitoring and so forth. That is absolutely essential. I mean, we don't really know where the water goes at this point, and you can have any set of legal reforms you come up with, and they're not going to work for the reasons you described unless we can account for where the water goes, measure it, have it reported, and then have enforcement action take place based on that. My colleagues at PPIC did a study that was published earlier this year that showed that during the last year of the last drought, about 1.4 million acre feet of water, that's about the amount of water the Bay Area uses each year, went unaccounted for in the Sacramento system. And I think that's a really good example of what you just described.
Well, I think the work you all have done on even quantifying as a gross level where the water goes in California has been a tremendous gift to the dialogue and really important work.
Right.
But we have a long way to go to be able to have a logical, workable system.
We just got one of the questions in from our audience that relates directly to what you folks have been talking about. It's directed at Professor Gray, but anybody can take it. Have other states implemented any of the components that you've outlined in the ecosystem water rights system?
There are elements, but I mean, nobody's kind of put the whole package together. We drew some of our ideas from Australia in the Murray-Darling Basin, and they have a form of ecosystem water budgets that are managed flexibly. I think there has been mixed success there for a variety of reasons, notwithstanding, or not, not the least of which is, they experienced some very severe drought, and I just don't know that they were equipped hydrologically or institutionally to really deal with that. But I think the answer is no. There are elements in different state laws and policies, but nothing quite resembling the whole package I described. California, it's funny, Felicia, California might be moving further in that direction than any of the other Western states, just based on the work that you started with the water quality plan updating.
Yeah, and it's interesting how other states are more quantified and more professional in their water rights system, but even a place like Colorado, which is sort of opposite day, they buy water a lot,
yes,
but they're very quantified, so they can target it and know it's going to get where they want it to go, which is the opposite sort of way to go. It's funny, I was almost late for this call because I was talking to someone in Australia about the Murray-Darling and the latest reviews and the fights that are going on now about it.
Yeah.
Hey, Brian, I think it's great to be aiming high and thinking in this new way of trying to put it all together in sort of a more ecosystem-based approach. It is, and it may actually provide an incentive for all of us to get things together to quantify, do a better job of quantifying things, and to make sure that the trustees actually have the power and the authority to act independently, as you described. One thing we found in this very complex settlement on the San Joaquin River is there's all kinds of pieces that don't always automatically go exactly the way you thought they were going to. For example, our independent restoration administrator, which is a great part of the settlement, requires funding that doesn't come from the federal government. All of the parties felt that it would not be a good idea to have the federal government be able to stop the funding of the independent restoration administrator. But finding the other funding has been a challenge, and the state of California has come up with some funding, and that's been great, but it hasn't been enough. And we need to keep that going in order to have that independence and in order to make it effective. Another thing is, the water rights system is under attack in various ways, and it benefits the people who were, the white male landowners from 100 years ago get off much better than everybody else. And it is a question about whether locking in the current water rights system as a way to transfer water into ecosystem approach, would that somehow have a negative effect on the effort to reform the water rights system? I'm sure you've given that some thought, but some of these things are in motion right now. They're in play, and so it's that's another thing that comes to my mind.
I'd like to refer back, if I could, to something that Felicia flashed by in one of her slides in her short course in the history of the universe. And that was the interplay between Native American claims to water rights and environmental water.
Yeah, it's interesting, and Hal referenced it a bit. It's you know, we talk a lot about the Western water rights system as a first in time, first in right. And the way the East does it differently, it's a more equitable allocation, but with licenses that get reviewed by the state every 20 or 30 years, and you have to justify that you still need the water. In the West, it ended up being using miners' law, water being seen as another element to be extracted for commerce and development. And as a result, the miners' rules, you know, the most senior person gets 100% of what they claim before the next person gets a drop. And so when the water board curtails, it's got to cut people off 100% if they're junior. It's a fairly harsh system. But the irony of that is that we call it first in time, first in right, but it started after a genocidal destruction of the people who really were here first, which were the tribes, where they were disenfranchised, they were killed, there were bounties on them. After the gold and silver were found in Nevada and California, they essentially stopped signing treaties. So even tribes that had legitimately agreed to treaties and reservations come with enough water to support those homelands, it all stopped. And so in California and Nevada, you have tribes that were completely dispossessed who are now watching a system called first in time, first in right, when they clearly were here first. And so the inequity of that is rather stark and grand, and a number of tribes and advocates are starting to call into question that system. I'll be working on this next year, but the question is, what will your alternatives be? Because you also have the equity of the people who've developed farms and invested based on that right, which is part of the reason for giving the right, where you have whole communities dependent on less expensive water to grow food and do different things. So there's going to be a need for thought to think about, how do you deal with this challenge of an inequity that is patently obvious on its face, and then what do you do about it? And so the tribes have called the question, have shown up far more at the water board on a couple of fronts. One is, in their petition, it's just the delay in action is hurting them, and they see that as inequitable. And for them, protecting water quality from harmful algae blooms and protecting fish that are important to their cultural and health lifeways is essential and important. And it's kind of a justice delayed is justice denied. And the other is an objection to not having been included in the VA discussions, where they and many environmental groups and others have been excluded from all those negotiations and conversations. And they also claim that that's a challenge. So that's where it'll be interesting to see what EPA's response is. But I think it's also joined an issue that's already had some hearings in the legislature, where people are starting to think about, well, what would we do about it? And you know, there are a number of alternatives, but one that they're considering in Australia, where they have a very similar challenge, of course, although they just lost an important thing at the ballot dealing with this issue. But one of the things they're considering is buying water. Just as we were talking about buying water for environmental purposes, one alternative would be to buy water to be able to both compensate some of the current holders of water while also getting water to the tribes to make up for the fact that we have this hypocritical system.
Terry, if I could just.
So is it your thought that if we got a big enough pot of money, there would be sellers?
Yeah, maybe. I mean, you don't know. There'll always be some sellers. The rhetoric will be not one drop, but then there will be sellers.
I'm sorry, Brian, go ahead.
I was going to say, and I think in that context, establishing and defining the property right on behalf of the Native Californians will be a major incentive to the voluntary transfers or sales of water. I just wanted to mention, I've been thinking a lot about this and reading a lot about this topic recently. I want to give two examples. It's traditionally we think of, the story goes that the native Californians, yes, they were here first and they had total dominion over the land and resources, but they didn't use the water the way that the Anglo settlers did, that the miners did, and later the farmers did. They didn't divert it from the stream for a beneficial use and so forth. There's evidence in the Owens Valley and the Mono Basin that the Nuumu people, what we typically known as the Paiutes, actually had diversion ditches, and they had them for thousands of years before there was contact. And there's still some physical evidence, and there's reports from an 1855 federal land survey that describes them as irrigation works. And I think that could well form the basis for a very credible claim based on the first in time, first in right principles, that those tribes and other tribes like that actually do have valid first rights to the water. The other example I wanted to give is that the U.S. Court of Appeals for the Federal Circuit in Washington has recognized that the 5 Klamath River tribes have treaty-based reserved rights to water to fulfill the purposes of their reservation with very senior actually the senior most priority on the river. But also they have time immemorial priority, ancestral-based rights, both to water, but also to hunt and fish. And to the extent that water is needed to facilitate their fishing rights, they have the most senior priority based on that. And the court also found that the Endangered Species Act and the limitations on water use upstream are a means of, among other things, not just protecting the salmon, but also honoring those senior water rights of the tribes. And the tribes have gotten together and formed a working group that we think actually could serve as a perfect trustee for the waters of the lower Klamath River. But I think we're very likely to see claims based on those legal doctrines, as well as I described for the Nuumu people, just our modern conception, or our 19th, 20th century conception of first in time, first in right. I think we're going to see a lot more claims from Native Californians based on those principles.
We have one more question from the audience. I think, Felicia, it was you who mentioned something else happening in 2026, and I assume that's with respect to the Colorado River.
Yes.
Would someone like to elaborate on that?
Well, there's a lot that's up for grabs because so many of the agreements were set to expire that divide the water between what's known as the upper basin and the lower basin states. And the current setup is that the upper basin states need to deliver what was seen as half the water when they estimated that there were 14 to 15 million acre feet a year, which there aren't. It's more likely to be closer to an average of 11, and some years, closer to 7 or 8, which puts a lot of burden on the upper basin, which doesn't have the same degree of storage as the lower basin does, Arizona, Nevada, and California. So there'll be discussions about that. There'll be discussions about the role of tribes, because tribes is apropos of our most recent conversation. Tribes were left out of it. There are quite a few tribes on the Colorado who actually do have reservations and do have treaty rights, and therefore have a date in time in priority that will go back to their reservation rights, but they don't just get it. They end up needing to settle their rights with the states that the water flows through. And the federal government over the years has been very slow to help them settle those rights. Although I will say that both the Obama administration, the Biden administration have made a much higher priority of this. And so far more tribes on the Colorado have access to their water, or portions of their water that are located in different states. Navajo has some settled and others not, for example, because they cover 3 states. And so the issue of the role of the tribes in the agreement is going to be a very big one. I spent a couple of days in Colorado at a conference on that was really interesting, because the tribes have organized into an initiative that is very powerful and very much respected. And so that will be a big part of it. Another issue that will be raised is how much, and not just how to allocate the shrinkage of the expectations on the water and how to divide it up, but whether the federal government can make certain judgments or even threaten to make certain, well, you can always threaten, but whether they can credibly threaten that they can make some choices about what's a beneficial use of water. Because while I talked about beneficial uses in the context of a water quality control plan, which means everybody who uses it for something useful, the notion of beneficial use, as was alluded to, I think by Brian and maybe by Hal as well, beneficial use in water rights means you're using it for something, but is it a reasonable use is another question. And in California, we have a whole constitutional amendment that gives the State Water Board the ability to say, no matter how senior you are, that's not reasonable, however you might use it. Other states do not necessarily have that. The reclamation law has, and what that set up the Hoover Dam and Glen Canyon projects, the way the reclamation runs the Colorado River, uses those words beneficial use, but they've never made a judgment. They threatened they might make a judgment about lawns, or they might make it a judgment that they were going to charge evaporative losses, like over Lake Mead and others, to the lower basin states. All of those are kind of up for grabs, both whether those are the choices that ought to be made in allocation and whether the federal government actually has the authority to make those sorts of choices. So there are other things, but those are sort of some of the biggest moving parts out there. And I think from listening to the experts who spend all their time on the Colorado, I think they think they're not likely to start from scratch because that seems impossible, but more likely to tinker around the edges.
Just a quick note on going back to tribal water rights, but specifically on the Colorado River. Not all, but a number, I think it's 23 out of the 30 tribes in the Colorado River Basin have quantified rights. Some of those were quantified by judicial decision, others by acts of Congress. And in Arizona, a number of the tribes with quantified rights are selling water to Phoenix and Tucson. So again, here you have a clearly defined water right that then results in a different allocation of water, an allocation of water that is valuable both to the tribes because they make money from their water rights, and then to Phoenix and Tucson because it's available water at presumably a lesser price than other alternatives would be. So again, I think that's something very important to look for. I will note, as I'm sure many people in the audience know, that the Supreme Court ruled last term that although the Navajo have federal reserved water rights, the United States government is under no obligation, no legally enforceable obligation to assert those rights on behalf of the tribe. That was a disappointing setback. And Justice Gorsuch, who's actually been a very strong advocate of tribal rights generally, wrote a very harsh, but I think also quite compelling dissent in that case.
Brian, I wanted to go back to something about your proposal, which is that it seems to me one immediate step that would be helpful across the board would be to figure out how do we quantify what the blocks of water are that would be subject to the trustee, and how do you determine what's in and what's not in. And what I'm thinking of is back in 1992, Congress passed the Central Valley Project Improvement Act, and there are some provisions in there that promise water to the environment. For example, wildlife refuges were promised what they call incremental level 4, the additional amount of water needed to bring the wildlife refuges up to the optimal level. And the salmon were promised water in the reallocation of water from the Central Valley Project. Urban and ag contractors, some of that water would be put back in the stream for the benefit of the fish. A lot of that water has never shown up, and it's never been available for the environment. And that's been a subject of great concern by wildlife refuge advocates and also by salmon advocates. And I'm just curious how one handles that kind of unresolved problem in trying to go to the next step of implementing a trusteeship. And it seems to me, well, let's at least start by figuring out what we all agree is in the category of environmental water that should be managed this way. And I think that would be a useful step no matter what. And it may be you'd have to go river system by river system or whatever, or water project by water project.
Yeah, and that's why I said to Felicia earlier that's why in our judgment, it's so important for the ecosystem water budgets to be funded primarily, in terms of water, be funded primarily by the water that is now set aside to meet existing regulatory requirements as those requirements get revised. Because if you don't do that, then you're kind of scraping around for water. The problem, as you well know, with level 4 refuge supplies under the CVPIA is that the law specified that water would be water acquired by the Bureau of Reclamation that would supplement the water under the level 2 supplies that is there on a mandatory basis. And I think so if you rely on donations and transfers, and I think this is one of the problems with the board's proposal, it's not going to be reliable and it's probably not going to be enough. And that's why what we're really calling for is different, more creative, and we would hope more effective management of the whole, as I said, the whole body of water, the whole block of water, much of which, the lion's share of which is the regulatory water that we described. But I agree with you. Those are problems, again, and I think you have to be very clear as to who has the ultimate regulatory authority, which is the board in this case, and therefore who has the ultimate authority to set what that essential block of water is for ecosystem uses.
I think it's interesting too that I think the board needs to be allowed to set it based on the science and then use flexibility in the implementation to augment it. But the bottom line has got to be enough water to protect the species and the beneficial uses. And we're just not there. I mean, even in the description of it being whatever, the voluntary agreements being 800 more than the 2019 BIOPS, which eviscerated the 2008 BIOPS by like 1 million acre feet of water, it gets you not to any better than we are today. And we know that where we are today isn't enough. So I think a conversation about an alternative structure would be far more viable if we were talking about a structure that had enough water in the first place. Then you wouldn't have environmental community throwing bricks from the outside and the tribes. If we were actually talking about the ability to actually do the regulations, setting the goal of the right amount of water, it becomes much easier to have a conversation about a different approach, whether it's the VAs or the trustee ID or any of it. But until we're able to get it together to realize that the ecosystem needs more water, it's all academic.
And Terry, I have a question back to Hal, but I don't want to cut off questions from the audience if there are any.
Well, yes, ask your question and then we'll see if we have time for one more question from the audience.
Okay. I was just going to say, Hal, I mean, the restoration agreement establishes a block of water and establishes a flow schedule. And that's, it's a firmly stated flow schedule, somewhat flexibly managed. Has that worked? And when you go to revisit the agreement in a couple of years, is that something that you're going to focus on?
Great question.
Great question. And, as is probably not surprising in a settlement that was negotiated over the course of a full year and then in Congress for 3 years, there are some areas where you don't always get the water that was promised. So for example, if you're doing construction in the stream, in the riverbed, because you need to do the construction in order to accomplish your restoration goals, well, you're not going to be able to release that water at that moment because that will create a problem. So you have to figure out, well, what do you do with that water and who has the right to use that water and when? And there's been a lot of water that has not been released, which has been repurchased by the Friant irrigation districts at a pretty nice price. And that has been a source of concern. There is also a problem with people who are not parties to the settlement claiming that they have been harmed by having water in a river, that the river that they have a constitutional right to, a dry river, because that's where, yes, how it was when they bought their house, and so or their farm, and so there is this tension. And the short answer is no, we haven't gotten the full amount of water that was promised. And yes, that is one of the issues that would have to be revisited is, what should the releases be and what should be the limitations on those releases, what should be the conditions.
Yeah.
And ultimately, the way the settlement reads is that the matter would be referred back to the State Water Board. So Felicia, once again, the State Water Board would be the happy recipient of these tough issues that had not yet been fully resolved.
All right, I'm looking at the clock and realize that I need to turn the operations back over to Ms. Lipsky.
Thank you so much. And I wish we had another half an hour because I think even with just another half an hour, there's so many more topics that we could cover. And I apologize to the people who submitted questions that we were not able to get to this time. Perhaps I can share them with the panelists in writing, and if they have some good answers, we can let you know what they are. But I did want to take a moment, as I know you all do, to thank this amazing panel for all of the wonderful information that you've shared with us. It's really been terrific. And also to thank Terry in particular for working with me for all these many months to put this together and for roping Brian and Felicia and Hal into this. It's been really a joy, and I often wish that I could even just record the planning sessions and then also put them up for videos too, because I learned so much in each of these, as I know all of us have. I do want to take a moment also to thank Audrey Barrett of the NJCHS for all the work she does to make this all happen so seamlessly. Yes, thank you for joining me and thanking her. And to our FBA partners, I hope that all of you will please get on our newsletter, njchs.org, so that you can hear about more programming. Watch the video of this program, which will be available off of our website in about a week or so, and share it with all of your friends. And also look at some of our former programs from Hawaii and Nevada. They were all, and Arizona, they were all wonderful. Sorry, I misspoke, Arizona. They were all wonderful. So I hope we will see you at some other event. And thank you all again for being here with us this evening. Good night.
Thank you.